They thought I was alone. No lawyer, no support, no voice. I could feel it the moment I stepped into that courtroom, the subtle shift in the air, the way conversations softened just enough to make room for quiet judgment. A few heads turned, then lingered a second too long. Not curious, not concerned, just certain. Certain they already knew who I was. Or more precisely what I wasn't. My father didn't even try to hide his smile. "Can't afford a lawyer," he said loud enough for the row behind him to hear. "That's really something." A few people chuckled, soft, polite, controlled, the kind of laughter that doesn't draw attention to itself but still lands exactly where it's meant to. I didn't respond. Because I knew something they didn't. And in less than an hour, everyone in that room would too. The courtroom smelled faintly of polished wood and stale paper, the kind of place where decisions linger longer than voices. I stood near the defense table, hands loosely clasped in front of me, posture straight without effort. Across the aisle, my family occupied their side like they owned the room. My father sat at the center, navy suit tailored to perfection, his posture relaxed in a way that suggested confidence not earned today, but practiced over years of getting what he wanted. My mother sat beside him, pearls resting neatly at her collarbone, her lips pressed into a thin line that could have passed for composure if you didn't know her well. I did. That line meant she was pleased. To their right, my brother leaned back in his chair, one ankle resting on the opposite knee, his gaze flicking toward me briefly before drifting away again as if I were no more than a passing inconvenience. Their attorney stood nearby, flipping through a thick binder, occasionally exchanging quiet remarks with my father. Prepared, organized, comfortable. Everything I wasn't supposed to be. I could still hear my father's voice echoing in my head. Can't afford a lawyer. He hadn't asked, he had assumed. And the room had agreed. I shifted my weight slightly, letting my eyes move across the courtroom without urgency. The judge's bench remained empty for now, but the clerk was already in place, organizing documents with practiced efficiency. A couple sat quietly behind me, whispering to each other. Somewhere near the back, a pen clicked in a steady, nervous rhythm. Normal sounds, ordinary. But beneath it all there was tension, thin, almost invisible, like a wire stretched too tight. "Still time to reconsider," my father said, his voice lower now, though no less sharp. "You don't have to embarrass yourself like this." I turned my head just enough to meet his eyes. There it was again, that certainty. The quiet belief that he understood the outcome before the first word had even been spoken. "I'm not embarrassed," I said calmly. My mother let out a small, dismissive breath. "Of course you aren't," she murmured almost to herself. My brother smirked. Their attorney glanced at me briefly, then leaned toward my father. "We'll keep this straightforward," he said. "Given her situation, I don't anticipate complications." I caught the hesitation before the word situation, the subtle adjustment, the polite substitution. It almost made me smile. Almost. I looked down at the file in my hands. It wasn't thick, not like theirs. No color-coded tabs, no stacks of exhibits. Just a clean folder neatly organized, every page exactly where it needed to be. They thought that meant I was unprepared. They thought wrong. The bailiff stepped forward, his voice cutting cleanly through the room. "All rise." Chairs shifted. Conversations died instantly. The judge entered with measured steps, his expression unreadable eyes scanning the room with quiet authority. We all stood until he took his seat, then sat again at his signal. "Case number 47-218, the clerk announced. Petition regarding estate distribution and contested ownership." Estate. Ownership. Words that sounded clinical on paper, clean, simple. They never were. The judge adjusted his glasses, glancing briefly at the documents in front of him before looking up. His gaze moved from my family's side of the room to mine, lingering just a fraction longer than expected. "Counsel," he said, nodding toward my family's attorney. The man stood immediately, confidence radiating from him as he stepped forward. "Your Honor, this is a straightforward matter. My clients seek to resolve a dispute concerning property that was quite clearly never intended to be held by the defendant." He gestured toward me without looking. "The defendant," he continued, "has no legal representation, which unfortunately limits the efficiency of these proceedings, but we will do our best to keep things clear and concise. A few faint nods from the gallery. Agreement. Of course. Very well, the judge said, his tone neutral. We'll proceed. The attorney began outlining their case dates, signatures, transfers of ownership. His voice was smooth, practiced, each sentence landing exactly where it was meant to. On paper, it sounded convincing, structured, logical. If you didn't know what to listen for. I stood still, listening carefully, not interrupting, not reacting. My fingers rested lightly against the edge of my folder, feeling the texture of the paper beneath them. Every claim he made, I followed. Every omission, I noted. Every assumption, I stored away. Because assumptions were where people made mistakes. And mistakes were where cases turned. At one point, the attorney paused, glancing briefly in my direction before continuing. Given the absence of any substantive counter-argument from the defendant, we believe the court will find in favor of my clients without difficulty. There it was again. Absence. Silence mistaken for weakness. The judge's gaze shifted toward me. You'll have an opportunity to respond, he said evenly. I nodded once. Yes, Your Honor. My father leaned back in his chair, exhaling slowly as if the outcome had already been decided. My mother adjusted her bracelet, her movements precise, controlled. My brother didn't even bother looking at me this time. They were already moving on. Already done. I let my eyes drift briefly to the judge, then back to the documents in my hands. The room felt smaller now, the air heavier, not suffocating, just focused. Like everything was narrowing toward a single point. Toward me. Good. I closed the folder gently, the soft sound of paper, meeting paper, barely audible, but it was enough. Because for the first time since I had walked into that room, my father's gaze shifted again. Not confident. Not dismissive. Just curious. It was subtle. But it was there. And that was all I needed. I lifted my head, meeting the judge's eyes as the attorney finished his opening. No further statements at this time, Your Honor. A brief pause. Then the judge turned to me. Whenever you're ready. I took a breath, not deep, not dramatic, just enough. Then I stepped forward. Thank you, Your Honor, I said. And for the first time that morning, the room went completely still. I didn't start with an argument. I didn't raise my voice, didn't rush to contradict anything their attorney had just said. Instead, I let a small silence settle first, not long enough to seem uncertain, just long enough to shift the rhythm of the room. It was a technique I'd learned years ago, though not here. Silence used correctly forces people to listen. My name is Emily Carter, I said, steady and clear, and I'll be representing myself today. No reaction from my family. They had already dismissed that fact. The judge nodded once. Go ahead, Ms. Carter. I glanced briefly at the documents in my hand, then back up. Before addressing the claims presented, I'd like to clarify a few points regarding the nature of this dispute. Their attorney adjusted his stance slightly, preparing to interrupt. I could see it in the way his shoulders shifted, the way his fingers tightened around his pen. He expected confusion, hesitation. He didn't get either. This is not simply a disagreement over property, I continued. It's a question of intent control and the timeline of ownership decisions made prior to my departure from my family's residence. My father let out a quiet, impatient breath. Departure. That was a generous way of putting it. I could feel the past pressing at the edges of my mind, not as a flood, but as fragments, controlled, contained. Because I didn't need to relive it. I just needed to use it. I was 19 the day I left. No dramatic fight, no shouting, just a conversation that ended in a kind of silence I hadn't understood at the time. The kind that doesn't ask you to stay. You're making a mistake, my father had said, not looking up from the newspaper in his hands. I'm making a choice, I had replied. He turned the page. That was the end of it. My mother didn't argue. She didn't plead. She simply watched me pack her expression unreadable, as if she were observing something inevitable rather than preventable. My brother had laughed. Military, he said, leaning against the doorway. That's where people go when they don't have options. I didn't answer him. Because at the time, I wasn't entirely sure he was wrong. Back in the courtroom, I shifted my weight slightly, grounding myself in the present. My family's claim, I said, is based on the assumption that I relinquished my interest in the property when I left. Their attorney nodded immediately. That is correct, Your Honor. The defendant's departure was voluntary, and no further claim was made for several years. I let him finish. Then I tilted my head slightly. Voluntary, I repeated. That's an interesting choice of words. A flicker of irritation crossed his face. The judge leaned forward just a fraction. Clarify! I nodded. At the time of my departure, I was given two options: remain under conditions that restricted my autonomy, or leave without financial support, without access to family-held assets, and without any expectation of return. My mother shifted in her seat. Subtle, but noticeable. That is not coercion in the legal sense, the attorney interjected quickly. It was a familial disagreement. Perhaps, I said calmly, but it is relevant to the context of intent. He opened his mouth again, then closed it. Because he didn't have a clean way to counter that. Not yet. I could feel the room adjusting. It wasn't obvious. No one spoke. No one moved in any significant way. But the energy had changed just enough to register. The quiet certainty that had filled the space earlier was no longer as solid. Doubt had a way of doing that. I continued, my voice even. Following my departure, I received no communication from my family regarding the property in question for a period of 7 years. The judge's pen paused. 7 years was not a small detail. During that time, I added, I was not asked to sign any documents relinquishing ownership. I was not informed of any transfer. I was not contacted regarding any legal changes. That's because my father said, suddenly unable to hold back any longer, you made it clear you didn't want anything to do with us. His voice carried across the courtroom sharper than he intended. The judge's eyes flicked toward him briefly. Sir, you'll have your opportunity. My father leaned back again, jaw tightening. I didn't look at him. I didn't need to. 7 years. They had said it like it proved something, like time erased responsibility, like silence meant consent. But time didn't erase intent. It revealed it. I returned, I said, bringing the focus back where it belonged only after being notified of a pending sale involving the property. Their attorney straightened. Which again, Your Honor, occurred well after any reasonable expectation of claim. After I was excluded from all communication regarding that property, I said not raising my voice but not yielding the floor either. He stopped. Not because I overpowered him. Because I didn't need to. The judge glanced between us, then made a small note on the document in front of him. That was the second shift. Small, quiet, but real. I could feel my brother's eyes on me now. For the first time since I had walked into the room. Curious, uncertain. He didn't recognize this version of me. That was fine. He wasn't supposed to. I adjusted the folder in my hands, opening it just enough to slide a single document free. I didn't present it yet, not immediately. Timing mattered. Everything here was about timing. I understand the assumption being made, I said. That I left and therefore gave up any claim. That I remained silent and therefore consented to whatever decisions were made in my absence. I let that settle. Then added, but assumptions are not evidence. The words landed cleanly. No emphasis needed. No dramatics. Just fact. Their attorney inhaled slowly, recalibrating. I could see him working through it, adjusting his strategy, searching for a way to regain control of the narrative. He would try to push harder now, narrow the argument, reduce it to something simpler. Predictable. Your Honor, he said, stepping forward again. Even if we entertain the defendant's interpretation, the lack of action over such an extended period does not constitute legal abandonment without formal documentation, I finished. He stopped mid-sentence, just for a second. But it was enough. Because now the interruption wasn't emotional. It was precise. The judge looked up. Really looked this time. Not at my documents. At me. And in that brief moment I saw it. Not recognition. Not yet. But interest. Focused. Measured. I lowered my gaze slightly as if unaware of the shift, though every part of me registered it. Because this was where things began to change. Not in one dramatic moment, but in small fractures. Hairline cracks in certainty. My intention, I said, is not to complicate these proceedings. A faint, almost ironic pause, only to ensure that they are accurate. The judge leaned back slightly in his chair, fingers resting together. Proceed, he said. And for the first time since the hearing began, it didn't feel like I was the one on the defensive anymore. The shift didn't announce itself. No one in that courtroom sat up suddenly or gasped or exchanged dramatic looks. It was quieter than that, more precise, like a weight being redistributed across the room, subtle but unmistakable once you felt it. Their attorney felt it. I saw it in the way he adjusted his stance, no longer leaning comfortably into his argument, but standing straighter now, more deliberate. His confidence hadn't disappeared, but it had narrowed, focused. Good. That meant he was thinking. That meant he was no longer certain. "Your Honor," he said. Recovering quickly, even if the defendant wishes to argue technical retention of ownership, the practical reality remains unchanged. She has had no involvement with the property for years. No maintenance, no contribution, no communication. He let that list hang as if each word added weight. Functionally, he concluded her claim is disconnected. Disconnected. Another carefully chosen word. I let it sit for a moment, then nodded slightly. I agree. The response caught him off guard. It was small, just a flicker in his eyes, but it was there. "You agree," he repeated. "Yes," I said calmly. "I have been disconnected. From the property, from the decisions made regarding it, from the communication surrounding it." I took a step forward, just enough to close the distance between where I stood and the center of the room, not aggressive, not confrontational. Just present. But that disconnection, I continued, was not mutual. A pause. That distinction matters. The judge's pen moved again. Their attorney opened his mouth, then stopped. He wasn't sure yet where I was going. He should have been. I slid the document I had been holding onto the table in front of me, aligning it carefully before looking back up. "I'd like to address the timeline more precisely," I said. "Proceed," the judge replied. I turned, slightly angling my body just enough to acknowledge both the bench and the opposing side. 7 years, I said. That's the period my family has referenced repeatedly. 7 years of absence, of silence, of presumed disinterest. I let my gaze settle briefly on my father. He held it this time. No smirk, no easy confidence. Just calculation. "I'd like to focus on year 3, I continued. A faint crease formed between the attorney's brows. Year 3 wasn't in his outline. Year 3. I remembered it clearly. Not because it had been easy, but because it hadn't. That was the year everything either held or broke. I was stationed overseas at the time, I said. My voice steady, measured. My access to communication was limited but not non-existent. I received correspondence, official notices, documentation. I tapped the folder lightly. But I did not receive any notice regarding changes to the property in question. That's because no formal change occurred at that time, the attorney interjected quickly. I nodded, correct. He blinked. Again, agreement where he expected resistance. It unsettled him. However, I continued, that was the year preliminary discussions began. The room went still. Not loudly, but enough. Their attorney's expression tightened. Objection, Your Honor. Speculation. I have documentation, I said, without raising my voice, without rushing the words. The objection died before it fully formed. The judge looked at me. You'll have an opportunity to present it. I inclined my head slightly, of course. I could feel it now. The room wasn't just listening. It was waiting. My point, I said, is not that decisions were finalized during that period. My point is that decisions were initiated, without my knowledge. I let that settle, then added, and that pattern continued. Their attorney stepped forward again, more forcefully this time. Your Honor. Even if preliminary conversations occurred, they do not constitute legal action. My clients were under no obligation to consult the defendant regarding hypothetical discussions. Agreed, I said. He stopped. Again. Because I wasn't fighting him on the surface level. I was letting him build his argument, while removing the foundation underneath it. But hypothetical discussions, I continued, often lead to concrete actions. I reached into the folder, pulling out a second document, this time placing it beside the first. And when those actions occur without proper notification, that becomes relevant. The judge's gaze shifted to the documents. He didn't ask for them yet, but he would. Across the room, my mother's posture had changed. It was subtle, just a slight tension in her shoulders, a stillness in her hands that hadn't been there before. My brother no longer leaned back in his chair. Both feet were now planted on the ground, his attention fixed. And my father? He was watching me. Not dismissing. Not mocking. Watching. As if trying to reconcile the person in front of him with the one he thought he knew. "You've structured your argument around absence," I said, returning my focus to the attorney. "Around the idea that lack of involvement equals lack of claim." "That is a reasonable interpretation," he began. "It's a convenient interpretation," I corrected gently. The distinction landed. I took another small step forward. "Because it assumes that involvement was an option." Silence. This time heavier. I could feel the tension now, not just in the room but in the space between each word, the careful balance of pressure and restraint. Push too hard and it becomes emotional, too soft and it disappears. This wasn't about proving them wrong all at once. It was about making it impossible for them to stay comfortable. "Your Honor," the attorney said, his tone tightening slightly, "we are moving away from the central issue. The ownership structure is directly tied to the decision-making process that preceded it," I said. "Not interrupting. Completing." He exhaled slowly, recalibrating again. This time it took longer. The judge leaned forward slightly, his attention no longer divided. "Ms. Carter," he said, "you're suggesting that the defendant, your family, initiated actions that ultimately affected ownership without proper notification." "Yes, Your Honor." "And you intend to demonstrate that?" "I do." A beat. "Then proceed carefully," he said. "Not a warning. A recognition." Carefully. I almost smiled. I reached for the first document, sliding it forward just enough for the clerk to retrieve when instructed. "Not yet. Not until it mattered most. Before I present these," I said, "there's one more point I'd like to clarify." The attorney stiffened slightly. He didn't like surprises. "My family has framed this as a simple matter," I continued, "a straightforward dispute with an obvious resolution." I let my gaze move across the room, over the gallery, over the rows of silent observers who had come in expecting something routine. "But simple cases," I added quietly, "don't usually require this much effort to control the narrative." The words settled into the space between us. Not loud. Not sharp. Just undeniable. For a moment no one spoke. Not the attorney. Not my father. Not even the quiet whispers from the back of the room. Then the judge broke the silence. "Ms. Carter," he said, his voice measured, "you seem unusually familiar with procedural nuance for someone without legal representation." There it was. Not the full question, but close. Very close. I met his gaze. Held it. And for the first time since I had entered that courtroom, I didn't look like someone standing alone. "I've had some training," I said. Nothing more. Nothing less. Across the room, their attorney's expression changed. Just slightly. But enough. Because now, he was starting to wonder. And once doubt enters a room like this, it doesn't leave quietly. The word training didn't linger long in the air, but the effect did. It was like a thin fracture running through glass. At first, almost invisible, then slowly it spread. Their attorney adjusted his cufflinks. Not because they needed adjusting, but because his hands needed something to do. My father shifted in his seat, his fingers tapping once against the armrest before going still again. My brother leaned forward slightly, elbows on his knees, now watching me with a kind of focus I had never seen from him before. No one said it. But the question had already formed. What kind of training? I didn't answer it. Not yet. "Your Honor," their attorney said, stepping forward again, voice regaining some of its earlier confidence. Though the edges were tighter now, regardless of the defendant's familiarity with legal terminology, the facts remain unchanged. My clients have maintained exclusive control over the property for years. They have invested in it, managed it, and made decisions in its best interest. He turned slightly toward the judge, reinforcing his position. The defendant's sudden reappearance, he added, coincides conveniently with a pending sale. That timing is notable. Convenient? Another word meant to shape perception. I let it pass. Timing is relevant, I said, but so is sequence. He frowned. Sequence? Yes. I reached for the first document and finally slid it forward, placing it squarely on the table. This, I said, is a record of internal correspondence between my family and a third-party broker dated approximately 18 months prior to the initiation of sale proceedings. The clerk moved to retrieve it at the judge's signal. Paper shifted softly as it changed hands. Their attorney didn't move, but I saw the brief tightening in his jaw. He hadn't expected documentation. Not like this. "Your Honor," he said carefully, "I would caution against placing undue weight on informal communications. Preliminary discussions do not equate to legal action." "Of course not," I said. Again, agreement. But this time I didn't stop there. "But they do establish intent." The judge's eyes moved across the document, scanning quickly, then more slowly. His expression didn't change, but his attention sharpened. "Continue," he said. I took a step closer, not toward them, but toward the center, toward the space where everything converged. "The correspondence outlines a proposed restructuring of ownership," I said. "Not finalized, not executed, but clearly initiated." I paused, letting the words settle. And notably, I added it references the need to avoid unnecessary complications from absent parties. The phrase landed, because it wasn't mine. It was theirs. My mother's fingers tightened around her bracelet. My father's gaze flicked just once toward their attorney. And in that single glance, something shifted. Responsibility. Pressure. That phrase, I continued, appears multiple times throughout the correspondence, always in reference to individuals who were not present, and therefore not consulted. Their attorney stepped forward quickly. "Your Honor, this is being taken out of context." "Then clarify the context," the judge said without looking up. A beat. The attorney hesitated. "Just for a second. But in a room like this, a second is enough." He cleared his throat. "The language is standard. It reflects logistical considerations, not intentional exclusion." Standard 1 repeated softly. I reached for the second document and placed it beside the first. "This is a follow-up exchange," I said, 6 months later. The clerk collected it. The judge read. And this time the pause was longer. Because the wording was different. Less careful. Less neutral. "Proceed," the judge said again, his tone quieter now. "In this exchange I said the same concern is addressed. But the language shifts. It references the need to finalize decisions before any claims can be raised." Silence. No movement. No interruption. Their attorney didn't speak this time. Because he couldn't. Not without contradicting what was now in front of the judge. I didn't press. I didn't need to. The documents were doing the work. Across the room, my brother exhaled slowly, running a hand through his hair. My mother's posture had gone rigid, her composure held together by habit rather than ease. And my father, he wasn't looking at me anymore. He was looking at the table. "Ms. Carter," the judge said, lifting his gaze, "you're suggesting that these communications indicate a deliberate effort to proceed without notifying all parties with potential claims." "Yes, Your Honor." "And that you were one of those parties?" "Yes." Another pause. Measured. Deliberate. Their attorney stepped forward again, but this time there was no smooth confidence, no practiced rhythm. "Your Honor, even if we accept this interpretation, it does not negate the fact that no formal claim was made during that period." The defendant, Ms. Carter, remained silent. He turned slightly toward me, seizing on what he thought was still solid ground. "Silence," he said, "has consequences." I met his gaze. "It does," I agreed. Then I tilted my head slightly. "But only when it's a choice." The words didn't need emphasis. They carried their own weight. The judge leaned back, fingers steepled now, his attention fully fixed. "Explain that," he said. I took a breath, not to steady myself, but to choose the next words carefully. "Silence implies awareness," I said. "It assumes that a person knew something was happening and chose not to respond." I let that settle. Lack of notification, I continued, is different. It removes the opportunity to act entirely. A beat. And without that opportunity, there can be no meaningful silence. The room held still. Not tense. Not chaotic. Just focused. Their attorney didn't interrupt this time. He couldn't. Because the argument had shifted beyond simple ownership. It was no longer about whether I had spoken. It was about whether I had been given the chance to. And that was a much harder position to defend. The judge glanced down at the documents again, then back up at me. "You've structured this argument very precisely," he said. "Not a question. A statement." "Yes, Your Honor." He studied me for a moment longer than before. Then his gaze moved slowly toward the opposing side. Toward their attorney. "Counsel," he said, "were you aware of these communications prior to today?" The question landed like a stone dropped into still water. No splash. Just ripples. The attorney hesitated. Not because he didn't understand the question, but because he didn't like the answer. "I was not provided with these specific documents," he said carefully. Another ripple. The judge's expression didn't change. But something behind his eyes did. A quiet recalibration. Then he asked the question that shifted everything just a little further off balance. "Should you have been—" Silence. Real silence this time. My father finally looked up. And for the first time since I had walked into that courtroom, he didn't look certain. He looked unsure. And once certainty cracks, it doesn't go back the way it was. The silence after the judge's question didn't break all at once. It unraveled. Slowly. Deliberately. Like something that had been held too tight for too long and finally began to loosen. "Should you have been," the judge repeated, his voice calm but sharper, now focused. Their attorney opened his mouth, then closed it again. His gaze flicked toward my father, searching not for guidance but for alignment. For something he could stand on. My father didn't move. Didn't speak. And in that stillness the answer became obvious. The attorney cleared his throat. "Your Honor, I can only work with the materials provided to me if there were additional internal communications that directly relate to the ownership structure being argued in this court." The judge finished quietly. Another pause. "Then yes," he added almost as an afterthought, "you probably should have been." The words were not loud, but they carried weight. Not accusation. Not yet. But direction. I didn't speak. I didn't need to. The room had already shifted again, subtly but undeniably. The neat structure my family had built, the carefully controlled narrative, had started to lose its shape. Edges were softening. Certainty was thinning. And in its place, questions. The judge turned back to me. "Ms. Carter," he said, his tone measured, "you've demonstrated a clear understanding of procedural nuance, evidentiary timing, and argument framing." He paused. "You also mentioned having some training." There it was. Not implied. Not circling. Direct. I held his gaze. Not defiant. Not hesitant. Just steady. "Yes, Your Honor." He leaned back slightly, studying me, not just what I had said, but how I had said it. The cadence, the restraint, the precision. It wasn't the kind of familiarity someone picked up casually. He knew that. "What kind of training?" he asked. The question didn't echo. It settled. Right where it needed to. Across the room I could feel it, every eye shifting, every assumption recalculating in real time. My brother leaned forward further, his posture tense now. My mother's composure had gone completely still, as if any movement might give something away. And my father, he was watching me again. But not the way he had before. Not with dismissal. Not even with curiosity. With something else. Something closer to recognition. I didn't answer immediately. Not because I didn't know what to say, but because timing still mattered. "I received formal legal training through the United States military," I said. No flourish. No emphasis. Just fact. The words landed, and for a moment nothing happened. No gasps. No visible reaction. Just processing. Then the judge's expression shifted. Not dramatically, but enough. "Military," he repeated. "Yes, Your Honor." He nodded once slowly, as if fitting a final piece into place. "That explains the structure," he said quietly. Not to me. To himself. Their attorney exhaled through his nose, a short, controlled breath. He adjusted his stance again, but this time there was no illusion of ease. The confidence he had walked in with was still there, but it had narrowed, tightened into something defensive. Because now, he knew he had misjudged the field. "Your Honor." He began attempting to regain ground. While the defendant's background is noteworthy, it does not alter the legal standing of the case. It alters how I evaluate her arguments, the judge said, cutting in not sharply but definitively. A line drawn. Clear. The attorney stopped. Because there was nothing to push against. The judge turned his attention fully back to me. Ms. Carter, he said, are you currently serving? Yes, Your Honor. A brief pause. Rank. Major. This time the reaction was not silent. It wasn't loud, but it moved. A shift in posture, a quiet intake of breath somewhere behind me, the subtle sound of someone adjusting in their seat. Because now, the room understood. Not completely, but enough. My brother's eyes widened slightly, the expression gone before it fully formed. My mother's hand tightened against her bracelet, the pearls pressing into her skin. And my father, he didn't look away. But something in his face changed. Something small. Something irreversible. The judge nodded again, slower this time. J.A.G. Core, he asked. Yes, Your Honor. The confirmation settled into the room like gravity. Unavoidable. For a moment no one spoke. Not the attorney. Not my family. Not even the quiet observers in the back. Then the judge did something that shifted everything. He turned. Not to me, but to the opposing counsel. Counsel. He said, his tone calm, almost conversational. Did you know that the individual you've been characterizing as unrepresented is a commissioned officer in the United States military trained in legal practice? The attorney's mouth opened. Closed. Opened again. No, Your Honor, he said finally. The judge tilted his head slightly. And then he asked, not loudly, not dramatically, but with a precision that cut through the entire room. Did you really not know who she is? The words didn't echo. They didn't need to. Because the impact was immediate. The attorney froze. Not visibly, not in a way that would draw attention to itself, but in the smallest, most telling way, he stopped moving entirely. No shifting weight. No adjusting papers. Nothing. My father went pale. Not gradually. All at once. As if something had been pulled out from under him without warning. My mother's composure cracked not in a dramatic gesture, but in the way her lips parted slightly, her breath catching just enough to betray the control she had been holding on to. My brother looked between them, then back at me, as if trying to rewrite everything he thought he knew in real time. And I stood exactly where I had been from the beginning, unmoved, unraised, unshaken, because this wasn't a reveal meant to humiliate. It wasn't revenge in the way they expected. Loud. Sharp. Public. This was something else. This was correction. The judge let the silence stretch just long enough for it to settle. Then he turned back to me. Proceed, Major Carter. Not Ms. Carter. Not the defendant. Major. And just like that. The room didn't look at me the same way anymore. Proceed, Major Carter. The title didn't echo, but it changed everything. It wasn't just recognition. It was calibration. The room adjusted around that single word major like a lens snapping into focus. What had once been interpreted as restraint now read as discipline. What had been dismissed as silence now carried weight. I didn't react to it. I didn't nod, didn't pause longer than necessary. I simply continued because anything else would have turned the moment into something personal. And this wasn't personal anymore. Thank you, Your Honor, I said. I reached for the documents already in front of the clerk. I'd like to enter both exhibits into the record. Admitted, the judge replied. Paper shifted. A quiet stamp. A formal action, but it carried consequence. Because now those documents weren't just statements. They were evidence. Their attorney inhaled slowly, straightening his shoulders. He wasn't done, not yet. But the way he moved had changed. There was no longer any pretense of controlling the pace. Now he was reacting. Trying to keep up. Your Honor, he said, even if we accept these communications as relevant, they do not establish that the defendant, Major Carter, was entitled to notice at that stage. The property was under the operational control of my clients, and all decisions made were within their rights as managing parties. There it was. A pivot. Not denial, he couldn't deny the documents. So he reframed. Control instead of intent. Authority instead of inclusion. It was a reasonable move. But it came too late. Operational control, I repeated quietly. I took a step forward just enough to place myself between the two tables, not confronting, not encroaching, just present in the space where arguments became decisions. That term implies a structure. I continued. Defined roles, defined authority, defined boundaries. The judge nodded slightly. Yes, it does. I met his gaze. Then I'd like to clarify those definitions. I opened my folder again, carefully, deliberately, and removed a third document,